What's up, y'all? So again, this is the non-lawyer coming back at you again with some more exclusive content. Now, the stuff that I'm going to give you, some of it is public information, and then some of it is public information, but only I have it, right? So there could possibly be somebody out there with some of the information I'm going to show you. If so, let me know who and put that in the comments below. But for the most part, I'm coming back at you to talk about, this saga between TIandTiny, Shakina Jones, or Shakina Johnson, whatever her name is, and Sabrina Peterson, right? So some of you may know that Ti actually made a song called "This Is What It's Come To," and there's actually a video of that song. This is what it comes to, and I found that video on Ti versus Tip. That's the YouTube channel. And essentially, the title of the video is what it's come to, right? So if you want to check that out, check that out. But essentially, in my personal opinion, it's really just a video that kind of reiterates everything, summarizes, not reiterates, it summarizes all the events that have played out between TIandTiny and Sabrina Peterson, and of course it's skewed towards Ti's perspective, right? So definitely go and check that video out. It's kind of interesting, but honestly, if you've been following everything, it's not going to be a big deal. Nothing in it is going to stand out. Nothing in that video stood out to me. If you're new and you don't really know what's going on, that is a good video to watch because it's going to give you Ti's perspective of what's been going on, right? So that's that. Now, let's get into the case updates, which is actually, in my opinion, exclusive information, right? All right, so I believe what I have is exclusive content. I don't think anybody else has this. So if you find this information on someone else's channel after today is basically June 24th, and eventually other people will get a hold of this information. But if you find within the next 10 days that someone has this information, let me know who they are. Put the name of their YouTube channel in the comments below, or let me know if you found this on Facebook. Put the link. Don't put the link, actually, because I know that YouTube blocks a lot of links. But just put the name of the YouTube channel and just say this is their YouTube channel below, or put the name of their Facebook page and say, this is the Facebook page below. Actually, a link to the Facebook page would be helpful, but more than likely YouTube is going to block that, right? But anyway, I think this is exclusive content. No one else is going to have access to this as I know it, right? So again, if you know who has it, comments below. I'd like to know who they are, just so that I can follow them and I can get exclusive information as well, right? But anyway, so I have before me, so the last time I left you guys, I left you with the possibility of Sabrina Peterson's lawsuit being dismissed. And that lawsuit could have been dismissed if Sabrina Peterson didn't prove that she had served TIandTiny, right? So what I have now is documents that Sabrina Peterson filed that is essentially proving her proof of service. But there's a catch here. There's a huge catch, right? The catch to this is that it's not actually service, right? Or it's a different form of service, if you will, right? It's a waiver of service, right? So if we look at this, it basically says this summons and other documents identified below are being served pursuant to section 415.30 of the California Civil Code of Procedure. Your failure to complete this form and return it within 20 days from the date of mailing shown below may subject you to may subject you or the party on whose behalf you are being served to liability for repayment or any expenses incurred in servicing a summons on you in any other manner permitted by law. Right? And it says if you are being served on behalf of a corporation, blah, 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 blah. We don't really need to read the rest of this. In all other cases, this form must be signed by you personally or by a person authorized by you to acknowledge receipt of the summons. If you return the form to the sender, service of summons is deemed complete on the day you sign the acknowledgement of the receipt below. So here's the thing. This is not actually proof of service, but the court accepts this, right? So my personal opinion. So I live in the state of Illinois, and typically whenever you start a lawsuit, you're typically going to have the sheriffs go out to the individual's home or place of business and basically hand the lawsuit along with other court material over to that person, right? And then that sheriff is going to themselves sign a document which is going to attest that they personally went out and handed these documents over to the individual or the defendant or the litigant in the case, right? That's actual proof of service because you're going to have, number one, a sheriff's going out to give them these documents, and then number two, the sheriff is going to sign an affidavit under the penalties of law saying that he's actually served the individuals in this case, right? That's not what this is. That's not at all what this is. What this is basically Sabrina Peterson getting TIandTiny to waive service, right? Now, again, this is done in California. I don't know how they do things in California, and I'm also not a lawyer. I really probably should have led with that. I'm not a lawyer. I haven't been to law school. I haven't had any special training. I don't work in the field of law. I have absolutely no special skills other than, reading and writing. And most of the reading is fumbling when it comes down to these legal documents. But I'm just throwing it out there that, I'm not a lawyer. I'm just some wacky guy on the internet who likes covering cases involving celebrities. And if you come to my channel before, you know that. If you haven't been to my channel, then now you know I'm not a lawyer. I'm just some Joe Blow on the internet reading legal documents. With that said, this is not a proof of service. This is Sabrina Peterson, in my opinion, tricking TIandTiny to waive proof of service. And the reason I say that it's kind of a trick, and it may not be a trick, I don't know what conversation was had between TIandTiny's lawyer, Andrew Bretler, right, attorney for Mrs. Harris, and then he signs it. I'm not sure what conversation was had between Andrew Bretler and TIandTiny, because typically, as I stated, in order for a lawsuit to begin, you have to serve the individuals. You have to have the sheriffs come out. And you typically wouldn't want to waive that service process, especially when you believe you're being hit with a frivolous lawsuit, right? And we're going to get into why I believe that this lawsuit is basically going to get dismissed, right? So when someone's suing you, there's a process that they have to go through. They have to go and pay the sheriffs to go out to your house or to your place of business to basically serve you. And there's a fee for that. And typically it's like, I think in Illinois, what is it? I want to say it's like I think the total filing fee for any lawsuit is going to be $400. Then it may be an extra $100 or $200 for the sheriffs to actually come out and serve you, right? But here's the thing. If the sheriffs can't catch you at your place of business and they can't catch you at your home, then you're going to have to go through other steps, right? Now, it's tricky for TIandTiny because God only knows where they're at. They could be in Atlanta. They may be in LA where this case is. Who knows? So if Sabrina Peterson couldn't get the sheriffs to go out and serve them, or if she had filed this in federal court and she couldn't get the federal marshals to serve her, then she has to go through the next step. And typically that next step is to simply hire a private detective. Now, again, this is where things start to get expensive, right? If you hire a private detective, you have to figure out whether or not you're going to hire somebody in LA or if you're going to hire somebody in Atlanta or some other place probably in between LA and Atlanta, because you basically, that private detective is going to have to figure out where TIandTiny is so that he can get these documents over to them, right? And it becomes tricky because each state has its own laws on how a private detective has to serve people, right? And I'm pretty sure there's probably a rule book, probably 20,000 pages long, that basically talks about the rules on how a private detective has to serve individuals out of state, right? So what I'm trying to get to is that once you get past the sheriff stage, this process can be expensive and time consuming. If they go after, if Sabrina Peterson hires somebody in LA to basically serve TIandTiny, that private detective is probably going to charge Sabrina Peterson anywhere from $15,000 to $20,000. And this is why I say this, because first, if the private detective is in LA and TIandTiny could be in Atlanta or they could be anywhere, then the first thing that the private detective has to do is figure out where TIandTiny is at. Then the private detective is probably going to have to catch a plane to wherever they are so that they can actually serve them. Of course, the better option would be for him to subcontract another private detective in another state to go and basically serve TIandTiny, right? It becomes complicated, right? It becomes really complicated. And this is one of those situations where the private detective will probably have to dedicate a huge chunk of his time to get TIandTiny served, right? So that's why I believe it would cost anywhere from $15,000 to $20,000 for a private detective to actually serve this on TIandTiny, because there's going to be a situation where you're going to be trying to um, hunt down TIandTiny so that you can put these documents in their hand, and it has to be done by the book, right? That's the most important thing. If it's not done by the book, then the whole thing is for naught, and you end up in a situation where your case gets thrown out because they'll just say, I was never served, or I wasn't properly served, right? So that's, and then if that doesn't work, right, after she shelled out that money, she goes back to court and say, hey, look, I've tried to serve these people, and I hired the U.S. Marshals. They couldn't serve them. I paid $15,000 to $20,000 for a private detective. That didn't work. So what I would like to do now is that I would like to serve them via publication, right? So what I'm trying to point out is that, this whole process can, number one, cost money, and then number two, it can eat up a lot of time, right? She could easily spend the next 6 months. She could have easily spent the next 6 months trying to serve TIandTiny. Now, I don't know. Again, I don't know what conversation was held between Andrew Brettler, right, the attorney for TIandTiny. I don't know what conversation he had with his clients, but me personally, I would not have wanted my lawyer to sign a document like this, because you're basically, number one, making it easy for this thing to get into court, right? It doesn't matter if you think you're innocent. It doesn't matter if you think you're guilty. Generally, one of your first defenses in any lawsuit is to basically claim jurisdiction. In this case, they can claim a violation of personal jurisdiction, because they can say, hey, I was never served. I didn't even know about this case. I thought I saw stuff on the internet, but I thought it was just a big hoax. I was never served with anything, right? But now they've given that claim up because their attorney has signed this. Now, I'm not saying that Andrew Brettler was thinking this way, but I know that there are a lot of money-hungry attorneys out there, and they will waive service just so that they can get the ball rolling, so they can start making money, right? Because again, based on how service goes, right? And if you don't serve a person, you can't proceed with your lawsuit. Your lawsuit gets thrown out. If at the end of the day you didn't serve that person and you can't convince the court that you did everything you were supposed to do, they're not going to let you post a publication of service, right? Do a publication of service, and publication of service is where you put an ad in the newspaper and say, hey, TIandTiny, I've tried to serve you multiple times for this case. I'm suing you. If you don't show up to court this day or this time, then a judgment is going to be put in against you, right? That's what publication of service is in a nutshell, in my opinion, right? So, but if you haven't done the basics, right, then you won't even get a chance to basically do a publication of service. The judge would just kick your case right out, right? So this doesn't make sense. I think some attorneys who sign stuff like this, they simply want to check, right? And I don't blame them. A lot of attorneys have spent years upon years in school, and they have years in experience, and they want to get paid for the work they do, and I get that. But signing a document like this, in my personal opinion, is not in the best interest of TIandTiny, because again, you have just given Sabrina Peterson a free pass on all that work that she would have had to done if they didn't sign this, right? So you let me know what you think. Do you think that TIandTiny's attorney, Andrew Brettler, should have signed this? Or do you know of any specific laws or statute in California that required him to sign this? For example, there could be some crazy law in California to say, hey, if you are their attorney, you have to sign this. If it was mailed to your office, you have to sign this. And that's the other thing about service. You just can't put something in the mail and basically serve a person that way, right? Unless that individual is waiving service, which is what you see in this document. So let me know what you think about this document. If you were TIandTiny, would you want your lawyer to sign this? Questions or comments below. So moving on, there's another proof of service, basically it's in the same shape and form. This time it is for Shakinajo Anderson. I've been butchering this woman's name all day. I've been calling it Shakinajo, but it's Shakinajo Anderson. But basically, her attorney does the same thing. He signs this, and essentially, he's waiving the service. Here in this situation, Sabrina Peterson probably would have had to pay to serve 3 different people. That would have made this very expensive for Sabrina Peterson, and it would have probably made it time consuming for Sabrina Peterson. Because think about it. You got to serve T.I., you got to serve Tiny, and you got to serve Shakinajo, right? And think about that for a second. So basically, you have to serve 3 different people. And this is kind of like a cheap way to do it. You just send a letter in the mail that says, hey, I'm suing you. Would you like to waive service? If so, sign right here, right? And it says notice and acknowledgement of receipt of a civil lawsuit, right? And that's all they're doing. They're acknowledging the lawsuit. Again, if I were in their shoes, I would not want my attorney to sign this. Let me know what you think about that, right? Would you want your attorney to essentially sign this, right? And it looks like yeah. So, and I have another proof of service here. I have another one. The other proof of service is going to be for T.I., right? Basically, same shape and form. It just so happens that Andrew Brettler is an attorney. He's the family attorney for TIandTiny. But that's still, in my personal opinion, Sabrina Peterson would have had to serve both TIandTiny had their attorney not waived this lawsuit, right? Because they could easily say, oh, well, we want, like if she tries to serve T.I. and she properly serves T.I., she can't expect that to apply to Tiny, because Tiny could easily say, or there could easily be a situation where Tiny and Ti broke up and they weren't communicating with each other, and essentially service upon Ti is not service upon Tiny. You have to serve them individually, but none of that matters because their attorney has essentially acknowledged the service of this lawsuit, right? So again, I just think this is a really bad move um, for TIandTiny. I think lawyers who do this, and I'm not saying Andrew Brettler had a motive to get paid. I'm not saying that he wants to milk TIandTiny, and that's why he signed this. But I'm saying there are lawyers out there who do things like that, because honestly, there's no work to be done unless TIandTiny actually serve. You don't basically waive, signature. That's stupid. Like, why would you do this? That's my opinion on that. So I also have the result of the rule to show cause. I think the last time I left you, Sabrina Peterson was at risk of getting her lawsuit dismissed, and her lawsuit may still be dismissed, right? So basically it says order to show cause, failure to file proof of service, case management conference, non-appearance, case review. And then it says the matters are called for hearing. The court verifies proofs of service has been filed as of 6/03/2021, June 3rd, 2021. The above captioned order to show cause is discharged. The court notes that a hearing on special motion to strike under CCP 425-16, and then it says anti-SLAPP motion. What in the world is an anti-SLAPP motion, right? And we're going to get into that in a second, right? And then it goes on and says, on the court's own motion, the case management conference scheduled for June 3rd, 2021 is continued to July 22nd, 2021 at 8:30 a.m. in the Department 40 at Stanley Mosque Courthouse. Notice waive, right? So their lawsuit could still be dismissed. And in order to actually explain that, we first have to look at what a anti-SLAPP motion means, right? Or what it is, right? I can tell you that a SLAPP motion or SLAPP, right? I'll tell you right now that a SLAPP is basically an acronym for strategic litigation against public participants, right? And we're going to get into this. We're going to get into I just told you what a SLAPP is, right? And basically what a SLAPP is saying is that you're basically trying to file frivolous lawsuits, right? I'm not saying Sabrina Peterson is filing actually I am going to say that, right? I am going to say that, but essentially what a SLAPP is that when an individual is trying to file a lawsuit for the sole purpose of harassing, or they're filing a lawsuit for the purpose of creating expenses for the other party, and basically making life difficult for the other party, even though that they may actually have a frivolous lawsuit. So they're taking a bullshit lawsuit and they're using it to harass another person. That's essentially what a SLAPP is, right? And we'll get a little bit deeper into what it is in a second here. Okay, so I am on California's legislative information website, and this website basically has all the statutes, and it basically tells you what the statutes are, right? And it gives a description and it lays the statutes out, right? So the section for the SLAPP, right, strategic litigation against public participants, is 425.16. And we're going to read some of this stuff, but we're not going to read it all because it's really heavy. And my personal opinion, it's worded to basically confuse the reader. If you're not a lawyer, this would be a really excuse to basically hire one, right? Because a lot of this stuff has to be decoded, right? So, but we're going to read this anyway. We're going to read some of it, right? So the SLAPP motion basically, or the SLAPP, right, starts off like this. It says, the legislator finds and declares that there has been a disturbing increase in lawsuits brought primarily to chill the valid exercise of constitutional rights of freedom of speech and petition for the redress of grievances. The legislator finds and declares that it is in the public's interest to encourage continued participation in matters of public significance, and that this participation should not be chilled through the abuse of judicial process. To this end, this section shall be construed broadly. So what is that saying? That's a lot of words there, very confusing stuff. And it takes, the average person to read that a couple of times just to figure out what the hell he's talking about, what they're talking about. So basically, they're saying that everyone has a right to freedom of speech, and they have noticed that there's been lots of lawsuits being filed, frivolous lawsuits being filed to disrupt freedom of speech. That's all that says. So they're coming out with this statute to basically reduce frivolous lawsuits being filed to stop freedom of speech and other constitutional rights. So let me give you an example. Let's say you come out and you use your freedom of speech to talk about a political issue or something significant to the public, right? And then because you said something in that, someone comes out and sues you for defamation of character, right? So this lawsuit, or this statute could be used to force the court to weigh whether or not the things you said were actually a defamation of character, or if the individual is using their lawsuits to basically harass you and prevent you from coming out and exercising your right to freedom of speech. That's essentially it. That's essentially all that says, right? So, and we're going to get into how this applies to TIandTiny in a second here, but I want to see if we can get any more juicy details out of this. And then it goes on, it says, a cause of action against a person arising from any act of a person in furtherance of the person's right of petition of free speech under the United States Constitution or California Constitution is connected in connection with a public issue shall be subject to special motion to strike, unless the court determines that the plaintiff has established that there is a probability that the plaintiff will prevail on the claim. So let me just highlight, right? Basically, it says unless, okay, so basically your lawsuit can be stricken, right? You'll be subjected to a special motion to strike, which means that your lawsuit could be dismissed unless the court determines that your lawsuit can be unless you as the plaintiff can establish that you'll win, right? Now this is going to be tricky for lots of reasons. One reason, which I've already read, is that you won't have basically the lawsuit has stopped at this point. They're freezing your lawsuit, right? And they're freezing it until you prove that you have a valid claim. So that's what this is saying, right? And not only do you have to prove that you have a valid claim, but you have to prove that you have a strong chance of winning, right? And the reason they're freezing a lawsuit because they want to stop people from filing frivolous lawsuits, because these frivolous lawsuits take up time and they take up money, right? So as this applies to Sabrina Peterson, from my understanding, this is what's happened. So Sabrina Peterson comes out and she starts encouraging people to come forward with their sexual abuse claims. From that point, T.I. basically comes out and he makes a speech. He makes a speech on YouTube, right? Actually, I think he puts it on his Instagram, and a lot of people copied it to YouTube, including myself, right? But he comes out and he basically defends himself, and he's using his basic right of freedom of speech. Now, from my personal opinion and from what I can remember, T.I. did not name Sabrina Peterson in that video. He did not address Sabrina Peterson specifically. He basically just came out and he basically just said some things. For example, he says what people are trying to do, and I'm summarizing, I can't, or paraphrasing, I can't remember the exact uh, words he used, but he essentially comes out and he says, people are trying to, get me to speak, and then when you speak, they sue you for defamation. And it's kind of funny because he knew exactly what was going to happen. He says people, come out with these allegations, and then they put you in a situation where you have to speak up for yourself, and then when you speak up for yourself, they sue you for defamation of character and get you to pay their legal bills. And then on top of that, what he didn't say is that what happens in a defamation of character lawsuit is that you could potentially say something that can be used to prosecute you criminally. But that's essentially all he says. If you think he said something different in that video, leave it in the comments below. I want to know. I want to hear from you because I don't think he actually mentioned Sabrina Peterson. I don't think, a lot of people are saying he basically proved that he was guilty. He basically lied on himself. I don't see that. I don't see any of that. All he said was that we only mess around with people who are into what we into. We know how to find what we want. He didn't admit to abusing anyone. He didn't admit to violating anyone. He didn't make any admissions whatsoever. So if you find that he said something incriminating in that video, leave your comments below. I want to hear your thoughts on that. If you find that that video was damaging to him somehow, comments below. I want to hear your point of view, right? So anyway, moving on. In making its determination, the court shall consider the pleadings and supporting and opposing affidavits stating the facts upon which the liability or defense is based. Now, honestly, and this is just my own personal opinion, you guys let me know. Based on the video that he made, I didn't hear him say anything that's going to be damaging, and I don't hear anything in that video that would justify this lawsuit. I don't hear it. If you hear it or if you've heard it, comments below. Let me know what you heard and why you believe it justifies Sabrina Peterson's lawsuit. Now, I'm not victim bashing. I'm not saying Sabrina Peterson is, she wasn't. I'm not saying, because the allegation is that Sabrina Peterson had a gun pulled to her head by T.I. I'm not saying that didn't happen. I'm not bashing Sabrina Peterson, right? But I'm just being honest with you. I just think the lawsuit that she's filed is basically going to fail. And I didn't even know about what a SLAPP was, but I believe the lawsuit is going to fail because it's a frivolous lawsuit. It's basically a frivolous lawsuit. You're basically looking for a reason to get him into court, and you're doing everything that he said you would do when he made that video, right? I just don't see it. I just really don't see it. But if you see it, comments below and let me know, right? So anyway, so they're going to take that video and they're going to review that video. In my personal opinion, I think that's what's going to happen. They're going to review that video and they're going to basically try to determine whether or not his right to freedom of speech, they're going to look at his right for freedom of speech, and then they're going to look at the things that he said, and then they're going to basically look at Sabrina Peterson's lawsuit and weigh everything and figure out if his freedom of speech should win or if her lawsuit should continue, right? And then it goes on, if the court determines the plaintiff has established a probability that he or she will prevail on the claim, neither that determination nor the fact of that determination shall be admissible in evidence at any later stage of the case, or any subsequent action, and no burden of proof or degree of proof otherwise applicable shall be affected by the determination in any later stage of the case or any subsequent proceeding. Essentially, whatever results that come out of the case, it basically ends at that. I'm sorry, let me say that again. Whatever the result is that comes out of that special motion to strike or that special hearing is going to die there. If they determine that Ti was basically exercising his freedom of speech, and again, I believe he was. I'm not victim bashing Sabrina Peterson or anyone else, but I believe that they're just going to say that man had freedom of speech, and he wasn't speaking maliciously towards anybody. He was just exercising his freedom of speech, right? And basically, whatever comes out of that, if he wins that hearing, then the whole case dies. If Sabrina Peterson wins that special hearing, then nothing in that special hearing can be used in the actual trial. And then it goes on, except as provided in paragraph 2, in any action subject to subdivision B, a prevailing defendant on a special motion to strike shall be entitled to recover his or her attorney fees and costs. Let me read that again. Except as provided in paragraph 2, right? In any action subject to subdivision B, a prevailing defendant on a special motion to strike shall be entitled to recover his or her attorney fees and costs. If the court finds that the special motion to strike is frivolous or solely intended to cause unnecessary delay, the court shall award costs and reasonable attorney fees to a plaintiff prevailing on the motion pursuant to section 128.5, right? So this is funny because, and this is dangerous too. It's dangerous for there's a lot of risk here for Sabrina Peterson, and I don't think that she probably thought about this, because if they grant his motion to strike, right? If they grant, and remember, there's 3 defendants. There's Shakinajo, TIandTiny, and actually, I don't know if Tiny. Well, let me not get into that. I was going to say I don't know if Tiny actually said anything, but I hear the word on the street is that Tiny was feeding Shakinajo information to say in Shakinajo's live, right? But anyway, and that's an allegation. I don't know that that's true. But at any rate, if any one of those win their special motion to strike, then there's a chance that they could force Sabrina Peterson to pay their legal fees. That would be crazy. That would be crazy, because I think Sabrina Peterson, and this is my opinion, again, it's not victim bashing, but I think Sabrina Peterson came out with this bogus lawsuit because this was her scheme. She went out and she got all those accusers, and then she filed her civil lawsuit after she got the accusers. And I think, again, the playbook that's been used against a lot of black celebrities is that you drag them through the media, then you file some type of civil claim, and then you hit them with a criminal charge. And all of that has played out, except it's not working. They dragged them through social media. I don't think that's going as well as that she thought it could go. Then she tried to get the authorities to involve. I'm sorry, she tried to get the authorities to investigate. I don't think that went well, right? Because essentially a lot of those cases were dropped. There may be 1 or 2 still under an investigation, but essentially some of those cases were dropped. And now she's struggling with this civil suit to get that in play. So she's using the playbook, but she's not running the plays right. I don't know what it is, but typically this playbook works on any black celebrity, right? Typically it works, right? It worked on Bill Cosby. It worked on R. Kelly. It just typically works. So I don't know why it's not working in Sabrina Peterson's case. Comments below. Do you think that? Do you know why this play isn't working on TIandTiny? Comments below. Let me know what you think. Right. So if we go down to in any action subject to subdivision B, where's subdivision B? Huh. Anyway, and then Yeah. So providing paragraph 2, except providing. So in paragraph 2 basically defines the situation in which Sabrina Peterson wouldn't have to pay the legal bill, right? And it basically says the defendant who prevails on a special motion to strike an action subject to paragraph 1 should not be entitled to attorney fees and costs if that cause of action is brought pursuant to section 6259, 11130, 11130.3. So basically, these are conditions in which they can't get legal fees if they win. We're not going to go through that. We don't have time for all that, right? So, and then it says this section shall not apply to any enforcement action brought against the name of the people of the state of California. Basically, this doesn't apply to the prosecution. And then it says, as used in this section, act in furtherance of a person's right of petition of free speech under the United States or California Constitution in connection with public issue includes any written or oral statements or writing made before a legislative action. And I actually already read this. Basically, it's basically defining situations where you can basically where you can file this SLAPP motion, anti-SLAPP motion, right? And most of them are kind of official situations, right? For example, any written or oral statement or writing made before a legislative, executive, or judicial proceeding. For example, a lawyer comes out or a legislator comes out and says, we're signing this to law to basically get all deadbeats, and he names a specific deadbeat or whatever, that legislator would be protected. Or let's not say a legislator, let's just say it's a city official or a state official, because a lot of those guys, they have special protections anyway, immunity. Anyway, you can't really sue a legislator. So basically, long story dog, this basically lists all the official protections that a person may have against a anti-SLAPP motion, right? And then moving on, the special motion may be filed within 60 days of service of a complaint in the courthouse discretion at a later time upon this terms it deems proper. We'll just keep going. All discovery proceedings in this action shall be stayed upon the filing of the notice of motion pursuant to this section. The stay of discovery shall remain in effect until the notice of entry of the order ruling on the motion. Basically, your case is at a standstill until you prove that your lawsuit isn't frivolous, right? And then it says, for the purpose of this section, complaint includes blah blah blah. We're not going to read that. An order granting or denying a special motion to strike shall be appealable under section 904(1), so you can appeal that. And then it goes on, any party who files a special motion to strike pursuant to this section, and any party who files an opposition to a special motion to strike shall promptly, upon so filing, transmit to the Judicial Council by email or facsimile a copy of the endorsed file caption page of the motion or opposition. A copy, basically just send us a copy of your SLAPP motion. And the Judicial Council shall maintain a public record of information transmitted pursuant to the subdivision for at least 3 years and may blah 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 blah. That doesn't mean anything. So that's it, guys. Look, so here's it. Let me just wrap this up. I honestly think that Sabrina Peterson is going to lose. Why do I think this? I'm not saying this because I'm victim bashing. I'm not saying this because I don't like Sabrina Peterson. I'm not saying this because I'm anti-Me Too movement. I honestly, I believe in the Me Too movement. What I think the problem with the Me Too movement is that they don't vet a lot of false claims, and they're allowing people to come up with these frivolous claims when their intention is just to basically destroy the lives or get revenge on people, right? But women do need to be protected. Women do need to have a venue to come through to basically enforce their rights. I believe in all that, right? If you're a black person, you have to believe in that, because you know, as an African American, you know your history. You know that you've been oppressed for years and for decades. I'm sorry, and not even decades, centuries, right? Your great parents were oppressed, and you know their children were oppressed, and even you probably actually faced some of that oppression when you have you know, people trying to enforce a lot of laws against you simply because they're prejudiced against you. And you know the same thing happens with women. But with all that said, is that I think there are a lot of frivolous, nonsensical, or just a lot of bullshit out there that is allowed to come forward, and they're doing it under the guise of the Me Too movement, and I just think it needs to stop. I personally believe this is one of those cases because when you look at the history of this whole saga, because it starts off with Sabrina Peterson being upset that Ti pulled a gun on her. We don't know why the gun was pulled, allegedly, right? Uh, we don't know why the gun was pulled, allegedly. We don't know what happened in that situation. Then it goes from that to Sabrina Peterson going out trying to get victims to come out and come forward, right? Then it goes from that to this defamation of character lawsuit, right? So I just think this is just a ridiculous case of Sabrina Peterson just either trying to get revenge or a bag or both, right? You guys let me know. And because of how things have played out, I believe that this lawsuit is 100% frivolous. In my personal opinion, Ti basically came out and he's basically using his platform and he's exercising his freedom of speech. And there was nothing in that speech that was malicious. To me, it was basically he was grief stricken and he was basically pleading with the public for help. Basically, that was a cry for help, in my opinion. And he's basically coming out and he's basically saying, you know, people come out with all these crazy allegations, and then once you come out and speak against it, they sue you for defamation of character and get you to pay their legal bills. And everything he said thus far is true, right? You know, so I just think it's just a frivolous lawsuit, and I think she's going to fail. I think what she really needs to worry about is actually paying the legal fees. But we'll know on July 22nd. We'll know what's going to happen. Her lawsuit is either going to ride or die. It's either going to die or it's going to continue on July 22nd. So that's it for this video. I'm wrapping it up. Please like, share, and subscribe. And thanks for watching.